so much for tuning into the Condo Pod. Welcome to the Condo Pod, brought to you by the Canadian Condominium Institute Eastern Ontario chapter. From governance and legal updates to maintenance, management, and community living, the Condo Pod tackles key issues affecting our condominium community. Whether you are a condo owner, director, or industry professional, you will find insights, stories, and expert advice to help you navigate the world of condominiums with confidence. We are diving into the topics that matter most to condo owners, directors, and professionals across the region. So on that note, let's dive right in. If you are not yet a member of CCI Eastern Ontario, don't forget to join us. For more information about how you can become a member, click the link below in the show notes. Folks, welcome back to part B of episode 1 of our Terry On series. Really excited to be jumping back with Evan and Christy. Let's go back to turnover. Both Christy and Evan mentioned it in our process a little bit earlier on. Christy alluded to the fact that it could be a bit more complicated than we would have liked it to be if we're jumping into the performance audit process at a later turnover as opposed to an earlier turnover. Why is turnover so important, Evan?
Yeah, so the turnover meeting occurs after the declarant has sold a majority of the units. So when the condominium is registered, the developer owns all of the units, and the developer often can be the declarant, not always. But they are the board. They are the guardians of the corporation, and they have the material interest in the corporation. As the developer declarant begins to sell units or close units to the purchasers, and by that I mean the title moves from the developer to the purchaser, and they take ownership and all of that. Once 50% plus one of units are owned by unit owners, the declarant has a period of 21 days to call a turnover meeting, and then a notice period of 21 days. So there's a combination there of the two. Um, Say the developer, ends being the majority owner of units on a Monday, they could call a meeting on the Tuesday for 3 weeks from then, or 21 days for that turnover meeting. They could also take 21 days to notify owners that they're calling a turnover meeting, and then that notice period of 21 days. At that turnover meeting, that's where the condominium corporation is officially turned over to the owners. So the declarant is picking up their big ring of keys, the seal of the corporation, the minute book, the governing documents, and they're saying, "Hey, owners, congratulations! This is now yours. You are now responsible for that." That at that meeting as well, owners will have the opportunity to elect the first board. So this is the first board of unit owners. Oftentimes there's a position we call the resident elect. So that's a position elected by owners only in the condominium corporation to ensure that they have a representative on the board. And then depending on your governing documents, if you're a 3-member or 5-member board, I think a lot now are 5. There's 4 other positions elected for staggering terms or for the same term. At that meeting as well, as I mentioned, you get the seal of the corporation, you get the minute book, you get copies of all the agreements that the developer or the corporation has entered into, you get the governing documents, copies of all policies for insurance, any records maintained under the Condominium Act, and any records that it has related to units or to employees of the corporation. 30 days after that turnover meeting, though, you get some of my favorite documents, and these are the as.
I love it when we have favorite documents in the condo.
Yeah, well, because they're so important to the performance audit.
Fair.
So 30 days after that, the developer has 30 days to turn over all warranties and guarantees for fixtures and equipment in the common elements, the as-built drawings for architectural, mechanical, electrical, plumbing, structural. You may get landscaping, you may get as-built specs, you might get site surveys. It's a gambit. It's outlined in section 43(5) of the Condominium Act. And there's a lot there that the developer has to give the condominium corporation. And why it's so important is that these documents, these drawings, they will then go to your performance audit engineer or architect, and they will use those as part of their review for your first year submittal. So it's It's they're just fun documents. I enjoy them.
Fun,
Tripping
fun,
over my words now, but yeah,
fun and important documents.
they are some
Yeah.
they are some of my favorites because I'm a very granular person and I like to kind of dive into these things. So when you have a set of as-built, you kind of get an opportunity to see what's behind the drywall because you
Mhm.
really have no idea where the plumbing runs or where the mechanical runs and things like that.
Mhm.
So then you have your blueprint, you have your starting stone, and then you can kind of go through the building and go, okay, if I'm not getting cooling to this unit or this column of units in the case of a high rise, you now have a better idea as to where some shutoff valves might be or various things like that. And these documents too will live with the corporation for its lifetime. So these will always be important to the condominium corporation.
Mhm.
And if you don't get them at the time of turnover, you do have some legal remedies that you can pursue
Mhm.
to try to get them.
Okay, Christy. So what would let's say we don't get them, and I remember just very anecdotally because you're talking about your favorite documents. When I first started practicing, I remember having to look at plans for the first time and
Yeah,
thinking, this is not what I went to school for.
that's right. That's
My
right.
background was criminal psychology. I thought I was going to be a criminal lawyer. Looking at plans was a big surprise to me. And thank goodness back in the day, I had Jim Davidson to help me figure out how to look at these plans. It's always nice to have a mentor as well
Exactly
that can
right.
help you figure out how to read these plans because they are so important. Like
Mhm.
they're just such important documents. So, Christy, let's say we don't get these very important documents. What do we do?
Well, there are legal remedies, as Evan mentioned. You'll want to consult with your manager and your lawyer and figure out if your situation is one that justifies the expense.
Mhm.
um, Legal remedies, unfortunately, the reality is that they are expensive and very time consuming. So it has to be worth it. But certainly there are cases where it is worth it. A court can order production of documents if a declarant has not produced what they've got in situations where the declarant for some reason has not arranged for the creation of these documents and the condominium corporation is required to go to the expense to create the documents itself. The court can order recovery of those costs to the condominium corporation. There's also just a straight $10,000 penalty, which is, if you're going to go to court, you may as well ask for that too because it's available.
Maybe we should make that penalty more out there so that maybe we won't have as many cases of a failure to turn over documents.
Yeah.
Yeah, maybe.
Perhaps that was the reason for the penalty.
Yeah.
Yeah.
Yeah. Yeah. Again, like whether or not you go to court, it's going to depend on the situation. I did want to mention though, just on the topic of um, turnover in the context of the Tarion process, that uh, even if the declarant is in charge of the board for throughout the performance audit period or throughout, the first or even the second year claim period,
Mm.
they are statutorily obligated to make the claims contemplated under the Condominium Act. So they're required to arrange for a performance audit and they're required to submit that to Tarion. If the condominium is turned over to a new board and you're halfway through the first year or even after the first year, the declarant controlled board was required to complete the process that we've been talking about. So make sure, you review the records and what's available through the Tarion portal to confirm what's been done and take steps to assert whatever additional rights you may need to assert.
Mm.
And that, I guess, that does stem from their duties and obligations as a director under the Condo Act, but also as a fiduciary.
They have a
Correct.
fiduciary obligation, yeah,
Yeah.
to the condominium.
So I think that brings us to extraordinary remedies. In our episode,
My favorite
I
topic.
was gonna say,
Favorite
episode.
documents to Christy's favorite topic. There we go.
Exactly. In episode 8, Christy had mentioned if everything goes well, here's the perfect process, but there are extraordinary circumstances and extraordinary remedies that you need to keep in mind for, let's face it, the majority of cases that don't go
That's right.
perfectly. So, Christy, tell us about some of your experiences with these extraordinary remedies and extraordinary circumstances.
So I so I'm so excited I can't even get it out. We talked a lot about the importance of the time frame to request conciliation, so the deadline to request conciliation, and the fact that if you miss that deadline, you are deemed to withdraw your claims. There is a provision under the Ontario New Home Warranties Plan Act that allows Tarion, it gives Tarion the discretion to extend certain timeframes, the timing for the request for conciliation being one, um, if there are extraordinary circumstances. So if a condominium corporation, if there's a particular reason why you've missed that deadline for conciliation, whatever the reason is, I mean, my best advice is going to be that you seek legal advice as soon as possible.
Mhm.
If you found out you missed the deadline, don't put your head in the sand, don't try to ignore it. Go talk to a lawyer, because the quicker they can act, the quicker they can take steps to apply to Tarion for that extension, the more likely you're going to get a positive outcome. So yeah, the point, I guess, is that where that deadline is missed, given the seriousness of the consequences, it's worth it to make an application to Tarion to extend that time frame. If Tarion denies that request, you have the ability to appeal that decision to the License Appeal Tribunal, which we're probably going to talk a lot more about in other podcasts. But this is the body that to which Tarion decisions can be appealed, and it's a separate body entirely, and they will review the request on its own merits and like a fresh set of eyes on the request. So if you're able to provide an explanation for the missed deadline, then there's a possibility you'll be able to get an extension for that. But again, you have to act quickly. So the quicker you act, because what the law says is that um, there has to be an explanation for the delay. And so the longer the delay goes without explanation, you may have an explanation for the initial missed deadline, but if you then wait 6 months to apply for the extension and there's not really an explanation for that 6 months, then the tribunal is not going to grant relief.
Mhm. And I believe you have had success on at least one case of getting the relief granted. So that's a bit of a teaser. We're going to dive into that case, I think, for our second episode.
Possibly. Yeah, I mean, we've had a few situations where we've made that request. And it's initially been denied, and we've appealed that decision, and that has worked out for the condominium. So
Okay, so folks, stay tuned. We are definitely going to dive into that in our second series, our second episode of our series. In the meantime, just let's just say the developer was keeping control of the board until a month or two past the conciliation deadline. Is that something that a court would look at as a potential excuse for when a new board jumps on?
This September, connect with Eastern Ontario's condo community at the 2026 CCIEO Ottawa Condo Conference. You'll join directors, managers, business partners, and industry professionals on Friday, September 18th at the Infinity Convention Centre in Ottawa. You get to learn, connect, and be part of Eastern Ontario's premier condominium conference. Register today at ccieasternontario.ca. See you there.
absolutely.
Absolutely. Okay.
That would be an extraordinary circumstance.
That's a black and white extraordinary circumstance.
Yeah.
It's very rare we get that in the law. So that's that again. I can see why that makes you excited, Christy, because again, we're all about protecting condo communities in this room. That's our passion, and we want to make sure that current and future owners have the protection and the rights that they're entitled to.
Yeah.
Mhm.
There's many other types of extraordinary circumstances as well, though. So and it's not a defined or limited list. So, situations where the Tarion designate has been ill and has not been necessarily keeping up on things, or there's been a death in their family, and as a result, they have not been tracking deadlines the way they should be. Natural disasters. There's all kinds of circumstances that could qualify as extraordinary circumstances. So, whatever the reason is, take it to a lawyer and have a discussion, and it may be that it warrants requesting the extension and seeing what happens.
And Ottawa is a bit prone to tornadoes these days, so it's not out of and flooding.
Yeah.
Your records get flooded. They're in the basement. You
That's
can't
it.
read them. Might be an extraordinary circumstance.
Yeah.
Another global pandemic. That could be an
No,
extraordinary
Well,
no.
and that has been.
But that was
Oh, it was.
Yeah, it was. Yes,
Okay.
yeah.
Oh, well, see, there we go, folks. Just talking about what could happen in life, and here we are, extraordinary circumstances. It is a fun. I don't know, extraordinary circumstances documents.
Listen,
What you
you're right. You're
the
absolutely
document.
I haven't seen the pretty documents. A very beautiful document. I know there is something about having a very beautiful document, and there's a meme somewhere. I'll have to find that. And
Yeah,
I'll share it with you.
and I think it just helps, and it kind of gets me to something that I am really passionate about, and that's education and education of this entire process. And it's not for myself in the position that I am in. It's not just about educating managers about the Tarion process and how all of this works, but it's educating owners and board members as well, because owners are board members and they don't just have the common element to think about; they have their own unit warranty to think about. And it gets a little interesting sometimes when the unit is defined within the declaration for the condominium. And Tarion may look at that declaration differently than five other people that look at the same document. So the education piece is really, really important. And yeah, documents help with education.
They do. Actually, that's a really nice segue into, I think, one of the other topics we want to talk about is the delineation between unit warranties versus common element warranties. So let's dive into that one. Then I'm not sure who wants to start us off on unit versus
Go ahead.
common.
Do you want me to? Okay. Yeah. So the unit owner's warranty begins actually at the time that they take occupancy. So it's not when they close on the unit; it's when they first take possession. And this can be well before turnover or the registration of the condominium corporation. But whenever you take occupancy of the unit, in your stack of documents, you will receive a Tarion certificate. And on that will be a registration number that you then have to take to Tarion and put your personal information in and open up your file, and that is your claim number. It's a totally different process on the freehold or condominium unit side than it is on the common element side. But there is interplay between the two. Condominium unit owners, often will have windows so they can look outside and enjoy their view. Well, those
We hope they
windows,
do anyway.
yeah, we hope they do. And those windows are often owned by the condominium corporation. Condo owners, though, new homeowners that are just in their units, they don't know that by no fault of their own. I mean, if I was to be living in a condominium unit and I'm looking outside my window, well, I would think that's my window. But they really only own, and this is where your declaration and your unit boundary description comes into play. But oftentimes they own up to that interior unfinished surface of the window in a closed position. Everything outside of that is the condos. So one funny one that I've had with Tarion once or twice is scratches on windows and on window
Yeah.
frames. And it's a funny one because some folks on both sides of the fence, be it the condo or on Tarion, will look at this differently. Some at Tarion will view it as a unit owner concern. Some on common element will look at it as a common element concern. Some managers will look at it as the unit owner. Some will look at it as the common. Every time that I've been a part of it, the window is a common element, regardless of the scratch. If your window is scratched on the inside of the window, that scratch goes through the unfinished surface. So it hits through that plane, automatically it's common element.
Right.
But if a Tarion representative says, no, you know what, that's freehold or that's the unit owner warranty, that can have a knock-on effect for the common element or the condominium, because then those two sides are going to talk and go, okay, well, you already warranted this as unit owner. We're not going to warrant it on common element. And I've had that discussion with Tarion, and Tarion has changed their mind and said, no, it is common element. But that can make for an interesting exclusion and warranty coverage, because from the condo side, we believe that it's common element, so we're going to put it on the performance audit,
Right.
because the performance audit is for any common element claim. There's a survey which we haven't talked about yet, but in that survey, we also ask people to note window scratches on frames, things like that. That can make up for quite a list in your performance audit, because each one is its own claim. And if Tarion says, no, you know what, we warranted this as freehold for this unit owner, we're not going to look at these claims on your common, that is a problem. And it's something that we have to be mindful of.
So let's pause on that. And then, Christy, maybe I'll ask you to just let us know about how your experience is in working with that particular situation where you've got homeowners who have preserved claims using their unit defect forms. and then you've got the corporation who maybe didn't have that information at
Mhm.
first instance.
Mhm.
Can we use that information in a later process to be able? I'm being laughed at. I like these tricky questions. Is it possible to bring that information over to the performance audit, or do we have to make sure that the corporation's engineer or architect has that information to throw it into the performance audit? What is our best practice? How does it work?
Yeah, so this sort of underscores the confusion that can occur because of the two separate processes that take place side by side. Um, Best practice is going to be for those unit claims. I'm using air quotes, to be provided to the corporation's performance auditor to include in the performance audit. So window scratches as the example. If a unit owner has recorded the window scratches as part of their claim process, it should be recorded as part of the common element process as well. Um, and that's for a number of reasons. One is to ensure that if Tarion, rejects the unit owner claim on the basis that it's a common element claim, it's preserved in the common element claim. And it's also because condominium claims are a little different than unit owner claims in the sense that the condominium corporation, obviously the common elements they're vast. There's a lot of common elements, and windows as an example, maybe you capture window scratches on 10% of the windows, but perhaps this is a problem that actually affects 90% of the windows. The fact that the claim has been preserved for the 10%, in theory, should preserve the claim for any common elements where this same defect exists. Tarion would not agree with me. I'm just going to put it out there. If there was a Tarion claims rep here, they would not agree with that. But that is what the law says. So where these types of claims do end up before the tribunal or a court, that is what the law confirms. Obviously, there's nuance to every case, but generally speaking, where a claim is preserved on the common elements in a number of locations, but it actually exists in many more locations, all of the locations where the defect exists should be covered by that warranty. So it is important to translate those unit claims onto the common element claim. Evan mentioned earlier unit surveys. This is one way in which that can be done. So as part of the performance audit process, a survey is provided to all unit owners where questions are asked about common elements that only unit owners have access to or that they would more frequently have access to. So things like the windows of their units, doors of their units, any part within their unit that of the common elements that can only be accessed through the unit, balconies, terraces, that kind of thing. Also provides questions for things like hallways, anything that unit owners would typically access. They can indicate if they've seen any problems with these things. Those unit surveys form part of the performance audit that gets submitted. I know we're going to talk in a later series about what those unit surveys mean for the performance auditor and what the condominium corporation is actually required to prove to Tarion. So we're going to deal with that later. But those unit surveys do get attached to the performance audit submitted as part of the first year claim. And so again, if there's window scratches and they're in those surveys, then that's preserved in terms of the common element claim through that. If it's not included and it's only included on the owner's own claim form, as a lawyer practicing in this area, I would argue that effectively preserves the common element claim. The tricky thing is that the condominium corporation doesn't get access to the unit files. So the unit owners would have to provide that information to the corporation to use as part of its common element claim in order for that to work.
So I think that once again highlights the importance of having people who understand the process with you at every step of the way, whether it's your manager, whether it's your engineer, whether it's your lawyer, etc. Because you could be easily persuaded as a new board member or a new board, oh, don't worry about that. The unit owner will take care of that, and we'll just deal with the common element items. Where in fact there is that giant interplay between the two, and we want to make sure we've captured everything for current and future owners alike.
Yeah, and it is important to hire people who have expertise in the area because the claims reps are helpful, and I wouldn't say anything otherwise in that respect, but they're not they're working for Tarion. So they're not working for the condominium corporation. They're not looking at the situation from the same perspective as a manager who has experience with Tarion or a lawyer who has experience with Tarion might. And so it really is. You can get rid of us after after the request for conciliation has
You're
been
right.
made.
You're right.
No problem. But definitely important to retain experts early on. It's invaluable.
Yeah, let's talk a little bit about that then. It's essentially a front loading of the process, if you will, to make sure that you're putting the resources, the time, the effort in at the beginning to make sure that it's done right. And I'll repeat it as well. Tarion is akin to an insurance company. Right? They have a certain amount of money, they have a certain pool of funds, and if they don't have to spend it, they're not going to be upset about that. So denial of claim is not out of the ordinary. So you want to make sure that your claim can be preserved, your claim can be perfected, that you can get the money that you're entitled to out of that process. So what what steps, which people, what do you want to do to make sure at the very beginning that you front loaded your resources to make sure you're successful long term? I know we touched on it already in episode A of or
Yeah.
part A of episode 1, but let's sort of do a full circle now and talk about how to make sure that you're front loading your resources, your time, your energy to make sure that you have for long term success.
Yeah, we're gonna certainly get into this more in a future podcast when we talk about how condos have to prove defects, when the condominium corporation has to prove the common element defect. Um, from the outset, though, I think it's really important to bring together a team of experts that are going to be able to carry the condominium corporation through the process. When we look at front loading cost, there's various things you want to look at as part of this performance audit, especially for the first year, because it's your best warranty coverage. It's workmanship and material defects, it's OBC violations, which is Ontario Building Code. It's everything with respect to mechanical and electrical and structural and everything.
Those beautiful drawings that
Those
we all
beautiful,
love.
beautiful drawings. But if you have any issues in those areas, you really need it to be covered, or you really need it to be noted in your first year performance audit, because it provides you the best coverage.
Mhm.
You want to bring that team of experts together between, somebody from your condominium management that has a really good fundamental understanding of Tarion. You want an engineering firm that has really great structural, mechanical, electrical, or if, perhaps one firm doesn't have all of those disciplines together, bring someone on that is going to give you an excellent performance audit, and then farm out some of the other specialties.
Right.
Speak to a team that just does electrical, speak to a team that just does mechanical, speak to one that just does structural, and have them all come in and do their own technical audit or their own performance audit. But provide the condominium corporation with their list of deficiencies that then you could give to the performance audit author, be it that engineer or that architect, and have them fill out the form and create the submission to Tarion. These are expensive. These assessments are expensive. We're in the tens of thousands of dollars per. But front loading those costs and setting yourself up for that success in that first year period, in that perfect world where the turnover isn't happening very late in the process, and you have a good board and all of these things come together, that will set you up for the most success. And that really will give you the best chance to have some of these deficiencies warranted through the Tarion process, um, because they are expensive, and it is really important that the condominium corporation and its owners be provided the coverage that they're allotted.
Mhm.
Yeah, I wanted to add to that uh, not to pile on, but
Pile on.
We are trying to protect condo communities. Sometimes there's some hard truths that go along with that. That's okay.
Yeah.
Yeah.
So condominium corporations are entitled to recover any first year budget shortfall from the declarant. So with respect to these costs, to the extent the costs of having the performance audit done properly, and retaining proper professionals to ensure that you have preserved your claim in the way that Tarion needs us to,
Mhm.
Mhm.
uh, those costs are recoverable or will likely be recoverable through the the first year shortfall process. So if your first year budget ends up, if you go over in terms of your first year operating budget, then you have a right of recovery for that difference from the declarant. And so just one more thing for a new board to keep in mind.
Be mindful of, yeah.
I also wanted to add something because I know Evan won't say it, but I will. In my view, having a manager, an experienced manager who understands the Terrian process and understands condominiums and what they're going through in the first and second years of their lives is incredibly important. There's so many rights that are available to condominium corporations within the first year and the second year of their life. And if you're not aware of those rights, you have no way of protecting yourself. And the way to become aware of those rights is having a manager who understands. Obviously, having, you can have a lawyer, you can have an engineer. We serve different roles, and I think we can be useful in many different respects, but it's the manager who's the linchpin to all of that. They're going to understand that, oh, there's an issue here that we need a lawyer for, or there's an issue here that we need a mechanical engineer, or whatever the case is.
Yeah, true.
It's the boots on the ground practical reality that could be missing with a volunteer board who have a million other things on their plate as well.
Well, and they have to rely on the manager's Rolodex.
Yeah.
Yes.
Really,
fair.
at the end of the day, like
Yeah.
the manager is hopefully going to know who to call, and if they don't know, they'll have a colleague who they can ask who will know who to call. But yeah, Christy's right. I mean, that manager is the linchpin, and they're kind of the glue that brings it all together, and they also have to build the relationships. The manager may not be the designate for the condominium corporation, so they may have a second seat in that Terrion process. But the manager should have a second seat in that process because they are constantly dealing with the board, constantly dealing with the developer, constantly dealing with the experts that the board retains to complete their submission. So they need to work those relationships and work the Rolodex.
Yeah.
Wow. Lot to think about. Any final thoughts on episode 1, how to set yourself up for success? We've gone through so much. Is there anything we missed?
I don't know that we've missed anything, but just to put a fine point on this last commentary that we've had, it's not enough to rely on the Terrion warranty claims rep. They are trying to help, and they are helping. They will provide information and assistance, but you cannot, as a condominium board, rely on that claims rep as your only resource for understanding what your rights are, what you need to do in any given situation. Again, it's going to be your manager that you really need to be able to rely on there.
The claims rep isn't your advocate. Would that be fair to say?
They're not your advocate. I think that they do provide useful information and education to boards, and I think they actively they do that in a proactive way. I think they work hard to do that, but they're not necessarily, again, they're just not looking at the situation from the same perspective. And on top of that, they're not going to tell you when you need legal advice. They're not going to necessarily tell you that you need to get a mechanical engineer here instead of, whoever you've got, because they don't have the proper expertise. So you need to be able to rely on somebody who not only has their eye on the bigger picture, but also has the proper connections to execute when something more is required.
Okay, lots to think about for part 1. Thank you, Evan. Thank you, Christy. That was fantastic. Folks, stay tuned to part 2. I'm looking forward to it. That's going to be our hot tips, hot topics. We're going to really dive into some deeper issues. We're also going to have an engineer join us for that one. So there's going to be 3 of us talking through these, or 3 guests talking through these fantastic issues. In the meantime, thank you so much for tuning in to The Condo Pod, your source for all things condo in Eastern Ontario. Be sure to subscribe so that you never miss an episode, and share this podcast with your fellow members of the condominium community. For more resources and upcoming events, visit us online at ccieastontario.ca. And until next time, stay informed, stay connected, and keep your community strong.
Thanks for tuning into the Condo Pod, your source for all things condo in Eastern Ontario. Be sure to subscribe so you never miss an episode, and share this podcast with your fellow condo community. For more resources and upcoming events, visit us at ccieastontario.ca. Until next time, stay informed, stay connected, and keep your community strong.